Hi everyone, welcome back to my channel. I just got in this motion to disqualify the prosecuting attorney in the Chad Daybell and the Lori VALLOW DAYBELL cases, and wow. So I figured I would wet hair don't care and go ahead and go live with you guys. First of all, I'm going to give you kind of like a paralegal view of this, and this is in my opinion and it's speculation and all that good stuff, but I'm going to read a bit to you and kind of show you how the sausage is made on these kind of motions. First of all, in my state, we don't put the attorney block at the top. We put it at the end. When you sign your name, then you put your attorney block, and that's got its, you know, your name, your firm, your address, your fax number, all that good stuff. But I guess every court is different. In my state, you start with this, okay? You start with the top, and it's got the case number. That's the thing the judge wants to, you want to make it easy on the judge. You want to be able to just blaze over it, go, okay, we're in the right, right venue, okay, this is okay, right here. And there's two motions. In my state, we separate the motions out. We put the motions right here. We don't put them up here, but whatever works. It's actually is two motions. I don't know if people mentioned that already, but yesterday, December 15th, 2020 at 2:55 p.m., it looks like Mr. Mark Means of the Means Law Office went ahead and filed this motion to disqualify the prosecuting attorney and a motion to extend time on the motion to dismiss. So we're going to go ahead and pick this apart. And also, they put her date of birth here. That's kind of odd. We don't do that in my state unless there's, we don't do it in my state, period. But if someone else had the same name, like you had Joe Billy Bob Smith, and to get, not to be confused with the other felon, Joe Billy Bob Smith, you maybe put the birthday. But that's kind of an oddity to me. But okay. Comes now the above named defendant, Ms. Lori Noreen VALLOW DAYBELL, in parentheses, by and through her attorney, Mark L. Means of the Means Law Office, PLLC, and move this honorable court for an order disqualifying and removing the special counsel, Mr. Rob Wood, from this criminal case, and that he be directed that he take no further action regarding any matter as it pertains to this case. So what he's saying here in this part of the motion is AKA remove this prosecutor. All right. The court has and is granted the inherent authority to remove the prosecutor on any grounds. Counsel for said defendant moves this court for this order as Mr. Wood has committed prosecutorial misconduct. Now, the next sentence is piggybacking on the previous sentence. This misconduct further supports the defendant's motion to extend the time to dismiss to allow the defense to amend its motion and present the newly acquired additional evidence. So what he's saying is that this motion, the one to disqualify Mr. Wood, also the misconduct that's coming out of this supports this motion, the defendant's motion to extend the time on the motion to dismiss. So there's two motions. How we would do it is we'd have motion 1 and motion 2, but they didn't do it that way. All right. The grounds of the motion. What you want to say is this is my problem, and here's where I'm coming from. Here's some support, some grounds. Said motion is based upon a recently received audio recording between Mr. Wood and the material witness Summer Shiflett, biological sister of said defendant, that occurred on October 2020. The recording clearly illustrates Mr. Wood's attempt to coerce, unduly influence, coach, and or intimidate said material in this case. So keep that in mind. The first problem here, the first allegation, the first ground is that Rob Wood, Summer Shiflett, there's an audio recording, and that he was doing these coercive, intimidating statements, actions to her. In addition, this is problem 2, an audio recording of Mr. Wood's interviewing another material witness, Zulema Pestenis, That is Alex, allegedly hitman Alex's wife. Also, at or around the same time, that's October 2020, discussing matters that support the state's position of the case. All right. So we have the first one kind of vaguely without any supporting evidence, talking about there's an audio recording, Mr. Wood and Summer, and he's coercing her, etc., etc. Then we got this certain audio recording, same time period, Mr. Wood is interviewing Zulema and discussing matters that support the state's position of the case. What in the vague book does that mean? Why would it be criminal or illegal or immoral to discuss matters that support a state's position of the case? I mean, it could happen, but I mean, that's as vague can be, right? Was he saying my position of the case is that Lori and Chad allegedly had the bodies placed on Chad's property. My position of the case is that this is a cult. My position of the case is that you were involved with them in some way, shape, or form. My position of the case. Okay. What my position of the case is, did you know a little bit about this? Yeah, and? I mean, I haven't said anything yet that's wrong, right? And I'm just spitballing. So, I mean, did the state offer Zulema Pastenis and Summer Shiflett any kind of deal to turn state's evidence? And then perhaps these audios are simply post-discovery. They've already had their discovery. And he's just trying to get them ready for trial. And that maybe they're trying to change their statements. And maybe he's just kindly reminding them that they agreed to turn state's evidence or to be a state witness. And if they change their mind that charges could come forth. Is that threatening or is that truthful? So let's go through the defense's assertions regarding these two claims. 1, the prosecutor misconduct, badly written sentence, but let's go on, violated the due process rights to the defendant's Idaho and U.S. constitutional right to a fair and impartial trial. The prosecutor engaged in coercive, unduly influence, coaching, and intimidation tactics to manipulate a material witnesses in this case. This sentence is so poorly worded. What he's trying to say is that Rob Wood violated Lori's due process rights, her Idaho due process rights, her U.S. constitutional rights to a fair and impartial trial, that he coerced and duly influenced, he coached, he also used intimidation tactics to manipulate a material witness in her case. That's what he's trying to say. 2, the prosecutor in this case violated the Idaho rules of professional conduct as well as the American Bar Association rules by his action statements and the like detailed on said audio tape. He says ABA rules, but I figured I'd go ahead and read it out for you. So, the prosecutor violated the Idaho rules of professional conduct. Well, anything in number 1 would result in number 2. If you're coercing, if you're unduly influenced, if you're coaching, if you're using intimidating tactics to a material witness, you are violating the professional rules of conduct in most states and also by the American Bar Association. 3, the prosecutor's misconduct could be construed under the witness tampering and witness intimidation statutes as criminal acts. This almost is smacking to me of that ice cream shop murder that all the YouTubers have been covering lately. Stephanie Harlow's is great, where it allegedly shows one of the suspects getting like a gun put to his head, and they're saying, "How is this the gun you killed her with?" Yeah, that would be an intimidation tactic used by a police officer. That would be coercive. That would be intimidating. That would be against the rules. All right. But the way this is phrased is very inflammatory. It's very hyperbolic. The prosecutor's misconduct has made him a material and necessary witness in this criminal case. And I circle this and I put the bodies being on the property case, because how is he asking Summer Shiflett and Zulema Pastenes questions in October 2020? How is that affecting the bodies on the property case? Because what did Zulema know about that? What did Summer Shiflett know about that? Now, if we were talking Melanie Gibb when she was around in that time period, I could maybe be like, okay, but that confused me. I don't know if he's confusing the non-yet charged murder case or if he is talking about this, which is surprising to me. I mean, for all I know, the October 2020 discussions that are on the audio tapes here being discussed, they could very well be about the upcoming potential murder charges, allegedly, not about the body burial. You follow me? Which are two different cases. 4. Prosecutor's misconduct has made him a material and necessary witness in this criminal case. Further, the defense intends to file additional motions as it relates to this evidence. Oh, I hope so, because this makes no sense. And intends to subpoena the prosecutor as a witness. Oh, this is going to be gold, guys. This is the end of 2020, right? This is how we're going to go out. See, because, the trial doesn't start until later, but, you can always have hearings and stuff like this over evidence, so. Another poorly written sentence in number 5. The prosecutor's misconduct has caused the potential for future civil, he means actions, because a word is missing here, directed at or involving Fremont County, Madison County, as well as the prosecutor and any and other entities involved or associated with this misconduct. All right, okay. I think what he's trying to say is that whatever Rob Wood has done is so egregious that he has opened himself up to potential further civil action directed at Fremont County or even Madison County. So now we're dragging Madison into this, okay? So stick with me here. Stick with me, please, because I always have some kind of weird, as told by Theolyn twist on this, okay? So 6, the prosecutor's misconduct has included concealing evidence in violation of Brady and the Rule 16 of the Idaho Rules of Criminal Procedure. Boop! Now listen, if this is true, this is bad, bad, bad for Rob Wood and the prosecution. You never want to conceal evidence. And if you don't know what Brady is and the Brady violations, let me just dumb it down. Whenever you have discovery, in my state, it's full discovery. Everything I got, prosecution, defense is going to get a copy of, get it. Everything defense has got, the prosecution's going to get. The only thing they can keep to themselves is how they're going to proceed. Their theories of the case, things like that. But it's not like against the law. They could go out and tell the press their theory of a case. It would be stupid because you're tipping your hand in a poker game. Okay? Now, if you have something that's exculpatory, like say something that proves that Chad was in Alaska, there's a ticket stub and a picture of Chad in Alaska during this time period, and it proves that he couldn't have done it, and you don't turn it over, that's a Brady violation. Okay? You cannot do that. Now, was there a bush that wasn't checked on the property and somehow, there's something that could be so tangential and it wasn't ever considered evidence and someone says, it's a Brady violation. They could say it, but you could be like, oh, that wasn't evidence and we didn't think it was evidence. You following me? So something that's like they know it was something they needed to turn over and didn't turn over, bad. And as poor as I think these motions are by means, and this is just my opinion, in my former paralegal opinion, as poor as these motions are, if this is true, it is bad. No bueno, you don't want to do that. So let's continue. Defendant, through her counsel, moves this court for an order disqualifying Rob Wood as a prosecutor in this matter, and that he be directed that he is to take no further action in this case in any manner. In other words, go sit down, you're off this case. That Mr. Wood be directed that he is to appear as a witness in the hearing set for this motion, that this court allow/grant for out-of-state subpoenas of the other parties to the audio recording. Stick with me on this one. That the court grant as sanctions all fees and costs in having to present this motion. that the defense shall seek additional remedies, which shall be detailed during the hearing on this motion, if appropriate. That the defense be permitted to submit this audio recording as evidence in this hearing to support this motion. Oh, God. Defendant respectfully requests that this hearing be conducted in person and that the hearing be recorded, unsealed, and a transcript of such proceedings be ordered. Now, where I am, this section here is called a prayer. It's like you're praying to court to grant your wishes, right? And in my time doing these, we tended to number their prayers so that they could grant prayer 1 and deny prayer 2. And he just kind of slaps everything together in one paragraph, and that may be how this court wants it. But let's talk about this. This is where you get my twist on things. All right. So what my takeaway is from this motion is this, guys. If this was an audio tape or tapes that were given late from the discovery, then Means would be putting on there, we just got this, from the Rob Wood, we got this from the prosecution, October 30th, and we haven't had time to review it. And then once we review it, we found that it had, he had coerced the witness, We don't see that here. So what that tells me, and when he's asking the court to allow this to submit this audio recording as evidence, what that's telling me is that it isn't evidence yet. It hasn't been in discovery. All right? What this tells me is that here's choice 1. Rob Wood made these recordings. Didn't think they were applicable to this case. Maybe to the murder case, but not to this case, and didn't turn them over. Or 2, Rob Wood called Zulema, because we're during COVID, did a Skype or, whatever. Same with Summer, maybe trying to, go refresh, getting them ready for trial as they do when you have a witness and you're getting them ready and you're just prepping them for trial. And that these little ladies decided to push tape to record the conversation. All right? And so they have recorded conversations with Rob Wood, unbeknownst to Rob Wood, right? So how's Rob Wood going to turn over something he didn't know existed? You follow me? That's choice 2. All right? I'm leaning towards choice 2, okay? Not that he recorded it and it pertains to this case and he didn't turn it over. That would be screaming Brady violation. That would be screaming bad. I don't know. Did he record it, think it pertained to the other case, didn't pertain to this one, so he didn't turn it over? I don't know. He's pretty savvy, guys. Do you think he did that? Or do you think these little ladies decided to take it upon themselves to surreptitiously tape this prosecutor? That's what I think. Here's also what I think. Is it a 2-party consent state? Because if it isn't, you've committed a felony. Doesn't matter what he said to you. Doesn't matter if he coerced you. Doesn't matter if he intimidated you. If you called my house in my state and didn't tell me you were recording me, you've committed a felony. If I'm out and about in the public, you can record me. If I'm in my house and you've called my house and you didn't call my answering machine, you called me and you start taping me, then you start playing it out and about, you've committed a felony. And the court is not allowed legally to play that in court. It's a felony to listen to it in my state. I've seen it in court. I've sat in a court case where this happened. Someone I knew wasn't even a witness. He was just tangential. And he decided when the police called him, he was going to tape them. And guess what? The defense decided that they liked what they heard, wanted to play it, and the court said, get that crap out, get that felonious crap out of here. All parties agreed that they couldn't even listen to it. And actually it was a huge nothing burger anyway. Like what he said was nothing, but it was hilarious. You're not allowed in a 2-party state unless you have both parties agreeing to being recorded. Did Rob Wood agree to being surreptitiously recorded? Possibly, in my speculation? Uh-oh, Idaho's a one-party state. Rob Wood, Skypes, whatever, Zooms, whatever electronic means, FaceTimes, Zulema and or Summer, and they decide to record it, and don't tell him, and they're in Idaho, it's fair game. It's okay. If they're in another state, same thing. If Texas, wherever they live, okay, wherever they're situated, that's what counts. It's where the people are situated. And if Rob Wood's in Idaho, which is a one-party state, and the other party's in a two-party state, doesn't matter. Bad news, bad news. So those audio tapes, if they were in anything having to do with the two-party consent state, they're not coming in. Doesn't matter if he threatened to kill your dog, it ain't coming in. But I just want to say, guys, don't get upset if Rob Wood has done something shady, and if it is in a one-party consent state, and it gets played in court, and if the judge finds that Rob has done some shenanigans and he gets booted off of this case, all they're going to do is put in the next prosecutor. He's got backup. They'll put that person in, and they will keep a rolling. The train keeps a rolling all night long. The train is not going to stop. And I've also seen in certain cases, which I won't mention, sometimes the person you get next is a more formidable opponent, and you end up crying and complaining and wishing to God you hadn't gotten that person knocked out or that judge knocked out. So let's just say, don't worry about it. It's all going to be fine. I do want to hear what kind of alleged coercion and intimidation and things he allegedly did and said to his own material witnesses. I know, guys, this is 2020, and 2020 has been wild, and I think it's going to go out wilder. And folks, even though the trials are set for later on, motions will go on constantly. So I have no doubt we're going to see all kinds of shenanigans like this. I'm going to see what the response is to this. And if you never hear these audios, it'll be because there was a two-party consent. It involved a two-party consent state. And you could have one that was in a two-party consent state and one that was in a one. So maybe we'll hear both. Maybe we won't. Maybe it'll be a huge nothing burger. Maybe it'll be a lot of hyperbole. Look, this wasn't the first motion to disqualify Ron Wood in this case, right? So, yeah, we'll see how this goes. So if you enjoyed this, if you got a chuckle, please push the like button. Please push subscribe. And without further ado, have an excellent evening. Bye.